Hello, everyone. Welcome. Welcome to our third From Theory to Practice webinar. Apologies for the 3 minutes of delay. We were waiting for people to join, but now you're all here, so thank you very much. So my name is Fabiola Mieres. I am from the ILO Research Department, and today we're hosting our third From Theory to Practice webinar from the ILO Research Project, Improving Compliance with Labor Protection. And today it's a very special day because we're going to learn and reflect together on the role of the European Labour Authority and cross-border labour inspections in Europe. In our previous sessions, we have focused on the case of the UK and Brazil, delimiting our analysis to those particular jurisdictions. But today, in contrast, we will reflect on why transnational alliances are built to enhance enforcement efforts in an approach that could be probably termed transgovernmentalist. We'll see, and the role of the ILA within it. So for me, this is a fascinating case. Well, of course, because I have been studying labor migration for such a long time, and ILA is legally mandated to strengthen labor enforcement cooperation in the context of free movement in the European Union. So we're very, very lucky to have Zane Rasnaka with us, who will guide us through this journey. And the presentation will last around 35-40 minutes, and then we will leave the space for questions. But do not hesitate to post your questions on the chat. And also, if you would like to take the floor, you can raise your hand. I will try to look at it and give you the floor. So Zane Rasnaka is a senior labor mobility officer within the inspection sector enforcement and analysis unit of the European Labour Agency. She's an international lawyer with expertise in European law and specialization in labor law and social policy matters, as well as institutional law of the European Union. At ILA, she provides legal expertise within the unit and coordinates multiple projects related to labor mobility and cross-border enforcement of EU law. Before joining the ILA, she was the senior researcher at the European Trade Union Institute in Brussels and legal advisor at the Ministry of Justice of the Republic of Latvia, working for the representative of Latvia before the Court of Justice of the European Union. Zane is also an affiliated member of the Institute for European Law of the QI Leuven and holds a PhD in law from the European University Institute in Florence. So, Zane, again, thank you so much for being here with us today. As you all know, this webinar will be recorded. So your questions and everything will be recorded and will be shared in the ILO website for those who couldn't be here today with us. So, Zane, maybe you want to share your presentation?
Yes, thank you. So thank you so much. I'm very happy to be here. And and enforcement and definitely cross-border inspections at the moment, that's very much a topic very close to my heart. And I'm happy to share the experience of the European Labour Authority with you. So I will just share the presentation and we can start. Do you see it? Yes.
Yes. So Zane, I think before we move on to our conversation, somehow now we see a beautiful tent in what could be a beautiful Nordic country.
Thank you. So do you see it, right? The presentation?
No, we lost it.
You lost it. Okay, I'll try again. Wait. Okay, let's go again. Sharing. Okay, here we are.
Perfect.
Okay,
I was just,
now you see it.
Yes. You just have to put it in display form.
Yes.
And I was going to say, because this is such a specific topic, not everyone is fully acquainted with the work of the ILA, European Labour Authority or agency, as you call it. So I would kindly ask you if you could give us, please, a bit of an overview of its landscape in terms of its mandate, its vision, its mission, so that we actually understand what's institutional context before we move on to the cross-border inspection.
Yes, exactly. So the European Labour Authority, ELA, is a relatively new agency. It was established at the end of 2019. Here you can see the sort of a timeline of its establishment. ELA was established on the initiative by the President of the European Commission, Claude-Jean Juncker. And I very much like the way he sort of proposed that ELA needs to be established. He said that it is absurd that we have banking authority which polices enforcement of banking rules, but we do not have a labor authority in the European Union. So therefore, we need to make sure that all EU rules on labor mobility are enforced in a fair, simple, and effective way. And hence, we need to establish a European inspection and enforcement body. So this was the way he explained what ELA will do in the State of the Union speech in 2017. Then followed the Commission's proposal, and ELA was established. In the first couple of years of the functioning of ELA, we experienced some difficulties because it was the time of COVID. So in fact, labor mobility was very much reduced at the time. And also such core issues as core functions of ELA as cross-border inspections, it was very difficult to organize back then. So, and when it comes to the broader context for establishment of ELA, we have more than 16 million Europeans who live and work in another EU member state. So we have a significant amount of people who have moved within the EU for work. We also have close to 2 million people who commute to work in another member state every day. And what was perhaps the political trigger for establishment of ELA was the posting of workers, because in the European Union, we have a fundamental freedom for the companies to provide their services across borders. And so basically, a company established in one member state can provide services in another EU member state. And in the provision of these services, the company can, in the context of the provision of these services, the company can also send its workers to, for example, I don't know, install Windows in another EU member state. And then these posting situations had created quite a lot of political discussions about how to ensure that the rights of these workers are protected. How do we ensure that they receive fair wages? The time of the establishment of ELA also coincided a little bit with the revision of the Posting of Workers Directive. So this is the key element what ELA was established for, to ensure really the protection and to facilitate protection and enforcement of the rights of posted workers. And what I also wanted to say, so as a lawyer, I feel it's very important to keep in mind what we are talking here about. So ELA has very specific competences. We are here to support and facilitate enforcement. But the enforcement is carried out still at the national level. So the EU member states are the ones who are responsible for enforcement. We support them, and we organize sometimes these cross-border aspects of enforcement. And when it comes to ELA's mandate, it consists of, in a way, 3 types of rules. So first of all, we have free movement of workers, and we have also social aspects of social legislation in road transport. These are really substantive rules which have created certain rights for workers at the EU level. So this is something we and these rules we are encouraged to facilitate the enforcement of these rules. So first we have some substantive rules created by the legal instruments within the mandate of ELA. And then the second group of types of instruments that we have within our mandate are the sort of a conflict of laws types of instruments. So this is where the posting of workers comes in, and also social security coordination, because posting of workers directives and also social security coordination regulations, they mainly contain conflict of laws rules pointing to the member state, pointing to the applicable regime of the labor law or social security regime, which has to be applicable to a worker in a certain situation. So this is the second big batch of Alice's work. And then finally, in our mandate is also such question as tackling undeclared work, because Ella took over the platform on undeclared work from the European Commission. And this maybe is an area where there is not so much. There are neither conflict of law rules there set at the EU level, and there is also not much in terms of substantive rules beyond trafficking in human beings. Maybe we have that directive on that, and there is also the employer sanctions directive. So this area is much vaguer in terms of substantive rules. So there is a big range of legal instruments that are within Ella's mandate. And as well, what I wanted to emphasize maybe is that we are allowed to facilitate enforcement only in these areas, only within the scope of these legal instruments. So this is important to remember as well. So the way we do it, the way Ella operates, we do carry out cross-border inspections, and I will go into that a little bit more in detail a bit later on. But we take a rather holistic approach as an authority to enforcement, and we try to make sure that we cover all the bases. So what we also work on quite a lot is information provision and services, because in the European Union, it is often difficult for companies and also for workers to be informed what are their rights, what are their obligations, how to actually comply with the rules in place, because the rules in place happen not to always be that simple to comply with, which we will also discuss later. And in our information campaigns, we target directly the companies and the workers in several sectors. We also facilitate cooperation with member states and often, for example, exchange of experience, good practices, because what we see as well and what we have seen in the first years of Ella's work is that often it is enough to solve a case to get the people around the table from different countries. And as soon as you facilitate this cooperation there, then the solutions can be found, because if we stay in our own silos within the member states, then these cross-border issues remain unsolved. We also offer mediation if there are disputes when it comes to the member states on how to apply the rules within Ella's mandate. We also carry out analysis and risk assessment, including operational risk assessment. So we offer a risk sort of analytical operational support also in the context of inspections. And we do a lot of training and capacity building activities. And finally, what is also within our mandate is EURES. Ella coordinates EURES network and supports member states in promoting cross-border job matching, which is also a big part of what we do. Yeah, so that would be the answer to the first question.
The ILO works, especially our colleagues in employment, they work a lot with EURES as an important network for public employment agencies and its model to replicate in other countries. But one of the things that our project has as a key objective is to understand a little bit more the causes of non-compliance. You know, there are many competing theories, which of course change according to economic sectors or the legal context, as you explained. But in your experience, what are the main causes of non-compliance, and how do economic and behavioral factors play in?
Yes, so I think it is, so from our perspective, from the perspective of Ella, it is important to remember we work in a specific context. So we work in cross-border context. It means that we focus mainly on intra-EU workers, so workers coming from one EU member state going to work in another. And we also focus on posting of workers, so these workers sent by companies to carry out a work in another member state. And what we also see quite a lot. We do not have a competence to deal directly with third country nationals coming to work in the EU. However, we do have a lot of cases with third country nationals because we are competent to deal with third country nationals who are being posted within the EU, and also third country nationals in case they can they get access to inter-EU labor mobility in some way later on. So we do see that picture as well. At the same time, we see particular issues. So we do not see the same range of issues, I think, as the national labor inspectors normally would. When it comes to the triggers of non-compliance, first, there is, I think, a certain element of simply the cross-border aspect of cases, the cross-border aspect, which is essential, the core of labor mobility itself is always challenging, because as soon as you have to deal with at least two systems in some way, or as soon as you have exercised labor mobility, more often or not, you're more vulnerable. So this cross-border aspect in itself always creates a little bit of complexity in comparison with standard typical situations. We also see there is also this element of territoriality principle, which is a great key core principle, lex loci laboris as a key element both for social security and labor law. At the same time, in the European market, where companies move, where for companies the market often is Europe, especially in highly mobile sectors as road transport, aviation, also construction is relatively highly mobile sector, as we see in terms of worker mobility. This territoriality of labor law enforcement creates challenges, of course, because it means that you have to cooperate. The national authorities of one member state have to cooperate with another. So ILO was created a little bit to address this issue. What we also see is lack of resources at the institutional level. And also lack of resources simply for the companies and also often for the workers to access information which is up to date, which is relevant to their situation, and which helps them to actually know their rights and assert their rights, or for the companies to actually comply with the requirements. Because we also live in a very multilingual place, and we live in a very complicated place when it comes to different labor law regimes and different rules. So both companies and also workers, certainly workers foremost, lack the resources sometimes to access those. This coupled together with sometimes lack of resources by national enforcement authorities who maybe lack resources to do massive preventive campaigns and massive information campaigns in situations also can be seen as a bit of a trigger for non-compliance. Then what we see, especially when it comes to the third country national workers being posted or moving within the EU, because of course when we go on inspection, we do see them a lot. What we see is this interaction between immigration, labor law, and social security law. And it is often complex. Labor law and social security law sometimes work in parallel, but are not entirely coherent when it comes to applicable regime, etc. So it can be difficult. Plus, immigration law, often the residence permit, the right to stay in a country for a third country national, is directly dependent on their employment situation. And therefore, they are much more afraid to lose their job. They are much more afraid to complain. And therefore, that creates a sort of a environment prone for exploitation and breaches of their working rights. So this interaction can sometimes serve as a sort of indirect trigger of non-compliance as well. Then complexity of legislative framework. Again, we see this walls of social security, labor law, and also immigration rules often, and they're frankly not easy to apply, because we live in especially in highly mobile situations, And in sectors with very high level of labor mobility, like road transport, it is very, very difficult to sometimes understand in which situation you are. Are you in situation of posting? Are you not? What is the correct regime? Which labor law applies to you, and then or which social security regime you have to pay into, and yeah, so this complexity of the legislative framework does pose its challenges. I think this complexity is often necessary because there is simply not a less complex way to solve it. To solve the situation, often at the same time, it requires necessarily a lot of information work, a lot of resources to counter the situation. And then we also see, when it comes to enforcement, simply the coordination difficulties between different actors involved both at the national and cross-border level can cause some difficulties with enforcement. And that is something we also try to address. When it comes to economical aspects, I mean, there is certainly some level of optimization of costs because labor costs a lot. So companies sometimes try to optimize their costs. And this can be a fertile ground for some sort of a circumvention of the rules. And if the enforcement afterwards is not there, this is also something which needs to be addressed. And again, when it comes to behavioral aspects, level of vulnerability, there we see a bit of a spectrum. We have workers who go somewhere for a very short time, and we have third country nationals who have just arrived in the EU. They are often much more vulnerable than a migrant worker who has been in the country for, more than 5 years, has permanent residence, has the language skills, has the resources necessary. So they maybe are less prone to exploitation and abuse of their rights, and they maybe are much better resourced as well to address their, to complain and assert their rights. And when we see the issues that we encounter in the field, so what we have encountered in our enforcement activities, and they seem to be prevalent throughout ILO's work, and this also is something raised often by the national authorities. What we see is undeclared work, very typical for in many sectors where ILO works. Illegal employment of third country nationals as well. Again, we also have quite a bit of labor exploitation situations, and something more specific maybe to the posting. We see a certain level of potentially bogus self-employment, so independent workers registered as self-employed, even though in fact they are independent employment relationship. And this is something very European, sometimes European specific, that we have this strict division between the workers in employment relationship who have the access to the full range of labor rights and full range of social security protection. And we have the self-employed who bear a lot of their own risks, have limited social security coverage, and do not get access to labor law protection. So this distinction between these two groups is very important, and we struggle with this a lot. We also see bogus temporary work agencies, these sort of labor intermediaries created just for the sake, for example, of posting of workers without actual economical activity in the country they are established. We see violation of social security rules, which is sometimes difficult to address, especially after the workers have already left the territory of a certain member state where they worked. And we also see these fraudulent letterbox companies, again, very long supply chains involving a lot of labor intermediaries, long chains of companies, which are difficult to tackle from enforcement perspective, and also difficult to establish liability in due time.
So to all the problems that we see at the national level, we add this important cross-border dimension that you nicely explained, particularly when it mixes third nationals with mobile workers in the EU context. So here is where the unique aspect of your work lies, and is this notion of the cross-border labor inspection. I think people are eager to hear more about that, how they're organized, how they are triggered, what's the rationale for conducting them, how do they complement or not national enforcement strategies, for instance. If you can tell us more a bit about that.
Yeah, sure. So when it comes to cross-border joint and concerted inspections, as they call them, this is actually a very much of a unique mechanism, I think, also at the global stage, because cross-border inspections in the way we do at this scope and scale, I think are not replicated or do not happen in other regions of the world, as far as I'm at least aware. I have been trying to find some examples. So if in the audience people are aware, I would be very happy to reflect on that. But in fact, at the very core, cross-border inspections are sort of the same, the traditional way of enforcement. These are the same labor inspections. They just happen to be organized at the cross-border level. So what is important in the way we function, member states still are entirely responsible for how they organize the inspection, how they divide competences between national authorities, how they carry out the inspections. What we do, we support this cross-border element. Yes, and I wanted to put the slide first to just show a little bit more holistically. So there are, in a way, all the inspections we do often are also related to the broader aspect of and broader functions of ILO. So we have enforcement campaigns, and often inspections are part of, especially preventive inspections in transports like road transport, for example, roadside checks are part of these campaigns. We have targeted inspections. We often have situations when member states or two member states come to us and say, look, we have this very complicated case where there are a lot of labor mobility issues. We want to organize, we need to organize an inspection across borders. And then from the side of ILO, we also organize inspections in the context of weeks of action, for example, in specific sectors or to tackle specific topics. And that we often do in collaboration with other EU enforcement networks or agencies such as RoadPol, Impact, Aquapol, etc. But when it comes to the sort of definitions, and the definition of a CJI, concerted joint inspection, at the EU level, which we use at ILO, is slightly different from the understanding of what an inspection is at the national level. So joint inspections are basically carried out in one or multiple locations in one member state with the participation from the national authorities of other member states. So let's say the national labor inspector, they see, okay, here are many, many workers from our neighboring country. We want to understand how they arrive, what is happening. There might be some breaches of their rights. So they invite the labor inspectors from this other member state to join in the inspection. So then they inspect the situation together. What happens there and why it is very useful to do this allows, there is a sort of certainly an element of learning, especially in the establishment phase of ILO in the early years. We saw that it was just useful for these visiting inspectors to see how their colleagues in another member state are working, exchange practices, exchange knowledge, and maybe take these best practices home and share. But what we also see in specific cases, this can be extremely useful if there are indeed workers from this other member state. The visiting inspectors speak the language, they know what is the situation back home, they can, get in touch with any companies in the chain in this other member state. So and really there happens this cooperation on the spot during the inspection, which has proven to be extremely instrumental in certain investigations. Then we also have concerted cross-border inspections. These are inspections carried out at the same time in 2 or more member states. Each member state authorities, they act only within their own member state, but they coordinate, they cooperate at the cross-border level and share, for example, evidence. So these types of inspections can be very useful, for example, in posting situations where in one country there's the headquarters of the company, the workers are sent and work actually in another member state. So at the same time, checks are done both in headquarters and in the place of work, and then the information and evidence is shared. So then we have situations, that the one inspection site, the inspectors who are in one side, they call to the ones who are in another site and immediately share information, immediately compare what the headquarters, what the management of the company, what they are saying with what the workers are reporting in the place. So this is also a very efficient way to do inspections. So these are the CGIs. We do not count them in the same way at national level mostly, at least in Europe. The inspections are counted according to how many companies are inspected. So this is how many inspections that have taken place. We often have inspections where many companies are counted, are checked within one inspection, or also inspections that cover multiple sites. So the counting and the understanding of the concept, what is a CGI, slightly differs from the national understanding. But at the end of the day, what happens is the member states still work in their own territory according to their law, with participation by observing, visiting inspectors. What we do, we support and coordinate this cross-border element. And when it comes to ILO support for CGIs, I think it is relatively generous support which we can provide. So we cover the travel, accommodation, all the costs which are related to the cross-border element of inspections. We offer possibility to have operational center in our premises, for example. We organize preparatory meetings. We also deploy experts on the spot to help with the application of EU rules. We provide interpretation, and this is something very important, often also for the inspections. And we also offer, we pay for interpretation also in third country languages, so not only EU languages, which is something also often used. We also offer, since the beginning of this year, operational risk assessment, where we carry out risk assessment analysis concerning specific companies involved in the inspection. And this is something now already, actually within the first year, quite relatively well used. And we have received very positive feedback about that role too. So this is what we do. And what we see in this, what we see also in Europe, that the resources which countries can allocate for labor inspection, of course, are limited. So then the support by ILO often helps and often triggers, also initiatives, and helps really to facilitate that enforcement actually takes place. So that's something. And I just wanted to maybe put on the key sectors where we do the most cross-border inspections, most CGIs. We have 2 bread and butter sectors at ILO, road transport and construction. So these are the 2 sectors where we have seen, so that's where the first inspections were piloted in these sectors. That is where we have by far the most CGIs. But at the same time, we now have quite few CGIs also in agriculture, in HoReCa, also manufacturing, meat industry. We are also expanding to other types of transport. So, for example, we work also in inland waterways, which I think is an extremely interesting sector from the labor mobility perspective. So these are the types of sectors we normally tackle in the context of inspections.
Mm-hmm. Thank you, Zane. Super comprehensive, and questions are starting to come up. Before I move to them, you mentioned the issue of risk assessments. An area of our project is very interested in the use of technology. So, it's everywhere now with the deployment of AI. How do you see countries, member states adopting these different technologies in their efforts, either to conduct these national specific inspections or actually in the analysis of the cross-border decisions. And I guess there would be different levels of development across countries, very unequal. But how does ILA tackle this? Thanks.
So basically at ILO we have a digital sort of a strategy, and one of our key plans and key tasks in the upcoming years as well, and we are already working on that, is we do facilitate and we do encourage use of innovative digital approaches for effective and efficient cross-border cooperation. We also promote use of digital tools and also data exchange between member states. So it's explicitly also laid down in our founding regulation in Article 7 and a couple of recitals, I think 17 and 25 of the ILO regulation. At the same time, I think what I could say about the digitalization, so first we have some member states which are really pioneering quite very interesting approaches and using AI and indeed risk assessment and also, sort of targeting inspections, because the first idea, which I think we all share, is that digital tools might help us in this under-resourced environment in which we operate, because of course we do not have the resources. The labor inspection never has resources to inspect every single company, every single employer, and we need to find effective ways how to target inspection. So this is one thing we try to encourage. Then another thing we do encourage a lot is exchange of information via digital tools. So we have certain systems at the EU level, like IMI, ERU in road transport, and also SC in social security coordination, where we also work with the member states to facilitate their use. But this is still challenging. We see that even in the context of specific investigations and inspections, the exchange of information can be challenging. Also, the way, even the way you ask a question for a certain piece of information can be interpreted differently by the receiving member state. And then when we add, and even greater, I think the challenges are when we start to use AI and in the risk assessment. So when it comes more specifically related to really what we do in ILO related to enforcement and in the context of my unit, what we do training activities, capacity building activities. We have, for example, organized workshops for analysts on the use of AI. And we continue doing that because they are in high demand always. We also use business intelligence softwares in our own risk assessment in the context of specific inspections when member states demand this operational risk assessment support. So this is something we do as well. What is the challenges? Okay, so first, of course, we have 27 member states. We have 27 different approaches. Many member states have their own systems, by using data mining. Some use AI. Some do not have almost anything in place. We also have multiple actors normally within one member state. So there often the data and information sharing is difficult. We also have quite strict data protection rules, and the way we share information in EU is rather regulated. So that also creates its own challenges, because we obviously want to be in line always with EU law, how we do it and how the systems work. The number of institutional actors, what we see often, for example, also to the EU systems. Certain institutions have access at national level, maybe institutions in other sectors do not. So then this creates some problems, especially if in cases which concern multiple aspects, multiple sectors are very complex. And then we still struggle sometimes with secure systems to exchange information rapidly, efficiently, within short time period. So that's actually sometimes CGIs can be also seen as a way to actually facilitate information exchange in the context of specific investigations when no efficient data exchange and information exchange tools are in place. So when it comes to exact examples, we have some member states who have relatively advanced systems, but I cannot really get into the details because that's the member states then would explain how much they can about their systems. But I wanted to mention some generally the type of systems and the type of approaches we can see. First, we have member states who use machine learning tools to detect, for example, benefits fraud by also using data from various databases, etc., at the national level. And some of these systems work also specifically target cross-border situations. We also have one member state, for example, has now quite advanced AI model for labor inspection. With the help of the system, they identify target companies, and then this helps. Obviously, it's not the only way how they identify their targets. There are also the traditional ways of complaints, etc. But they also use AI for this, and that seems to make increase efficiency. And then we also have certain member states who also predict which are high-risk companies for certain types of violations, and for example, in relation to posting of workers. And that's often enabled by the data obtained through the notification of posting situations. So these are the types of systems we see, but what we struggle with are still obviously in establishment of these systems. We need to make sure that data protection rules are obeyed. We also need to make sure that these systems are not biased in the way they work, are non-discriminatory, and there are technological and many challenges.
Yes, this is also something that came up in our previous session on the case of Brazil, and I take the opportunity to publicize a bit that tomorrow ILO is doing his official launch of the Observatory on AI and work in the digital economy. So we invite you all to tap into that. I think there will be a lot of potential for collaboration and learning more about these different tools. I'm quite conscious of time, so I'm going to wrap up one question and trying to include a question from a colleague. We wanted to move a little bit more on the barriers. One of the key areas of our work is to understand what are the barriers to achieve compliance with labor protection, and being these actors, those tasks with enforcement, a key actor in addressing this in the different areas that you have been explained. But also, I think it's important, especially which is more institutionalized in the context of Europe, to think about the role of the social partners. And in terms of the barriers, also, I think it's quite related to a question from our colleague, Maria, who is the global coordinator for the Fair Recruitment Initiative in the ILO. And she would like to know how issues related to abusive recruitment practices are considered addressed, in particular abuses that are committed by labor recruiters themselves. So I think, well, of course, under the umbrella of the initiative, she's interested in possible role of labor inspectors in detecting and addressing these recruitment frauds, which I guess is by private recruitment agencies, but also sometimes it can happen with partnerships with other national entities, right? So I think the recruitment question is linked to the barrier to compliance with labor protection for all this landscape of dissonance between immigration and labor law that you were explaining. So I leave you that I would like to have a few minutes for other questions that are coming up. So if you can continue with that. Thanks.
Thanks. Sure. I think I will just proceed to something I brought. So, for example, this is a quite typical situation we see, and this is really directly related to recruitment and the situations which are very difficult. Even though this is a very typical cross-border case, it is very difficult to tackle from an enforcement perspective. First, what we typically have, we have often recruitment in the third country, and somewhere outside in the EU by specific dedicated recruitment actors working in this country, who then find potentially workers or sometimes self-employed for companies working in the EU. So then the workers often enter through a member state where, for example, they have an easier visa regime for labor purposes, because there are a lot of bilateral treaties, visa regimes, which facilitate migration. But then instead of working in this member state where they enter, they often then actually go to work in another member state. So, and then it's often a sort of already a gray zone in terms of their migration situation. There they work for group of companies in potentially in another member state. But what we see then is often these same workers are actually posted to the member state number 3, where the actual work is carried out. And they maybe are not even carrying out the work in the second member state where they are. They also often are registered as independent, so therefore they do not benefit from the posting rules and the protection of posting of workers. And then these situations are extremely difficult to tackle. First, who is liable and at which situation in this whole chain? Who is the employer? Are they workers? And where should the Social Security be paid? If it hasn't been paid and the workers, for example, have left the situation, how can authorities tackle that? There's also great vulnerability here, because if the workers work as self-employed, often they themselves can be liable for a lot of infringements potentially. Obviously, we do not want that, so we want to reclassify them. But how do we do it, and what are the consequences of reclassification in the sending members? So these are the situations we see, and this is what we try to tackle. And this cross-border and corridors of posting are often difficult to tackle. So when it comes to when it comes to social partners, actually social partners are one of the key actors. How information sometimes arrives at ELA, and also how and they have a key role in actually raising awareness, because otherwise situations, especially at the national level, otherwise situations often can be completely undetected also at national level, because these are often workers involved in these situations. They are not the type of worker who has the resources to complain, who have the agency to complain and assert their rights. So in fact, social partners and trade unions are key. What we see at ELA, we have European social partner organizations took a very active role in the establishment of ELA. They are observers in our management board, members of stakeholders group. They're regularly consulted in our initiatives. They're essential part in our information campaigns. But more specifically, when it comes to enforcement, national social and partner organizations, they can also participate in cross-border inspections if it is in line with national law. And this is something very relevant, for example, for Nordic countries, but also in other member states. We have had social partners taking part directly in our inspections. And a second thing, something I want to advertise a little bit, is that the social partners can suggest cases to ELA, which we then move forward and potentially organize inspections in this context. So this is something I wanted to also advertise a bit. And I think the presentation will probably be shared with the participants. So the details on that I will just leave and not explain, I think, now. So that will be it from my side.
Thank you, Sanne. It's okay. That's great. We have some minutes to addressing some questions. So if everyone wants to raise their hand, there's another question about ILA dealing with the shrinking of the state agencies in particular, and the fact that labor inspectors at the national level face decreasing budgets, resources. You explained a bit that you provide some support. I think the question is, how do you work around these issues? If you can elaborate a little further.
I mean, we cannot really work around it. So I think we also, in a way, suffer from that. Not in terms of our own resources, maybe, but more indirectly, because we see also that there are some member states extremely active who have the resources, who organize a lot of cross-border inspections, and then we see others who maybe do not have the resources, who have very few resources in terms of staff, etc. What we try to do, first, we do offer quite generous support. And what we also have seen, that this organization of these cross-border inspections is seen as valuable, often at national level, from the national authorities as well. And then maybe support politically at national level is also allocated more to to these types of enforcement actions. So basically, the labor inspection becomes a little bit more of a priority at the national level, perhaps because of this international visibility of the situation, because if we have a country who cannot afford, who cannot organize any inspections, that's noticeable then, and that's seen. That what else we try to do? We try to support them with capacity building. We have extensive capacity building plans and trainings. So where we try to strengthen the resources, at least knowledge-based resources. We also have this strategy how to support digital innovative plans. Ideally, in the future, maybe ELA can also really support in practical terms use and implementation of digital approaches, which might then lighten the load and really create more efficiency. But of course, it is a struggle. It's not something. It's not an easy solution, and the solutions often have to take place at the political level, either at national or European level, which is a bit beyond what we can do.
Mm-hmm. Mm-hmm. Yes, thank you. Would you say that ILA is working with member states towards a more proactive approach, or a complaints-based approach, right? With opening the space for cases. I think the slide said you had 0 cases so far. This question lies because there are these models, right, of compliance and enforcement, and whether ILA really has an intention. Can it actually promote one model over the other?
Yeah, I think basically, if one looks carefully, then I think we have de facto worked in a very proactive way, because otherwise I think we wouldn't have had the first inspections, we wouldn't have had the initiative. So what we do from ELA's side, we organize weeks of action. This is something we propose to the member states. Of course, they are free to participate or not, but this is something, and many inspections each year take place in the context of these weeks of actions. They can be sector or they can be issue oriented potentially as well. So this is something in a way where there is a certainly proactive role of ELA. We also do receive and many actually more and more targeted proposals by the member states where they have the issue. So now they are familiar with the ELA process. They know they know and value the support we can offer. So then they come to us with inspection. So then this is more passive way. I think we support them, but again, this wouldn't have been possible, I think, if we wouldn't have taken the proactive approach, and we still do that. When it comes to social partners, so actually we do have quite close cooperation with them. Officially, we haven't ever had yet a case which would have been initiated by the national level social partners, partly because I think the European social partners might be a more natural stakeholder with which directly ELA interacts. At the same time, we have taken on, there are inspections which are closely related with the information submitted by social partners. And we also work on the first own initiative cases where we, as ELA, propose to organize a CGI in certain situations based on our own assessment and the information we have. So it's very much of a mix. I think there has to be also a general healthy mix between targeted and also preventive sort of enforcement. So we try to also achieve that because we also need to, in some sectors, we just need to raise awareness about how labor mobility rules apply. In other sectors, actors are very well aware about these rules, but struggle to comply. So there we need more targeted enforcement activities.
And Zane, just to finish, can a member state refuse the services of ILA, if it's a cross-border situation?
Yes, they can. So, for example, we have not really, I think, had situations like that normally, because we have worked in a very sort of collaborative way, and we are very thankful actually for member states that they use our resources, our support. But of course, member state remains the ultimate authority. Member state decides whether they want to do a CGI propose a CGI, and if there is one member state who proposes we want to do an inspection in this other member state can always refuse. And the member state can also refuse if ILO proposes an inspection on own initiative. That's always it's completely member state discretion. At the same time, in certain situations, they also have to explain why, and that can also sometimes help in actually facilitating enforcement activities. And sometimes inspection is not needed. Sometimes really what is needed is a meeting or exchange of documents, etc. So then, or the situation already, all the companies or workers have left the territory of a certain member state, then there's no need maybe to do an inspection in that specific case.
Yes, thank you. We're close to finishing, but I think, well, I would like to thank you again for your generous time. And one of the things that we'll be continue thinking in terms of the models I see in the cross-border dimension is actually joining co-enforcement and strategic enforcement, which normally in the literature are presented as separately. Either you have co-enforcement or you do a lot of work on strategic intelligence enforcement on these tools that we discussed. But actually in this context, the cross-border terrain provides for actually co-enforcement as part of a strategic but this is something to think about further. Also, the development of AI tools is very important. And I would like to thank all the participants for your time. I know there are a lot of webinars these days, so thank you so much for being with us. And we will continue with our series. The last one will be in November, and we will have Anna Booth from the Fair Work Ombudsman in Australia. So stay tuned for that. And thank you very much, and we hope to see you soon. Thank you.
Thank you.